Hello and welcome to the SLW Institute webinar, Electronic and Digital Signatures, Obtaining Signatures when Attorneys and Inventors are Working from Home. Our speakers today are Andre Murray, Peter Ribaffoni, and Michael Lynch. In light of current events, we wanted to take this opportunity to share some thoughts on this pertinent topic. Please submit any questions using the Q&A feature in the Zoom menu. Our speakers will address questions at the end of the presentation. Thank you very much for attending the webinar today. And with that, I'll turn things over to Andre.
Okay, great. Thanks, Michelle. Let me just get control of the slides here quickly. So hopefully I have that, and we're going to advance to the next slide. Okay, just 1 second here, if you can hang with me. Okay, Bree, maybe you could just advance it. I think it'll be easier to slide 3. Yeah, so good morning, everyone. Just wanted to extend a hearty welcome. Thank you for joining us. So by way of introduction today, we're going to try to tackle the why, how, and what of electronic and digital signatures. To quote Simon Sinek, always good to start with the why. And we're going to be doing this with particular reference to the patent procurement process. What we're going to be sharing today is based largely on our experiences with digital signatures over the past few years. We've had a number of clients ask us to use digital signatures or approve that we use them where possible and really where it makes sense. And we found this kind of varies greatly from client to client. Some have a higher risk tolerance for some of the potential risks and challenges, or have procedures in place to deal with that. But we're gonna share some of our learning with you today. But I think the overall trend really is that we're seeing, agencies and laws evolving towards a much broader acceptance of electronic signatures, and we anticipate that this is going to accelerate, particularly given the current pandemic, where people are not proximate to the usual support systems. So just at a very high level, the why of electronic signatures. I think the primary driver we're seeing from most of our clients is that it's a great experience for their inventors, particularly as people are working remotely now and don't have access to printers and shipping and that type of thing. We're seeing a much greater interest in that. But also further advantages are really administrative advantages, and Peter's going to dive a little bit into that. But I think what we have seen and what we hear from our paralegals is that generally we're able to file a lot quicker, or a lot more quickly than we were, or for cases where we are looking to get wet signatures using digital signatures. So it really can cut down the time to filing in certain cases. With respect to the how and the what, I think what you're going to hear today is really the keyword is perhaps flexibility, and you need to be flexible based on a few things here. Number one, risk tolerance, but also who the inventor is. If the inventor is the CEO, it may not be good to send him or her an electronic signature request, but also where they're located and that type of thing. So I think that's at a high level. Next slide, please. So with respect to the who and what as well, just to tee things up, I think we wanted to look there are a few differences here that with respect to documents and with respect to agencies and how these agencies deal with electronic signatures. So what this table over here is really trying to show is that there are a number of different types of documents that we're going to be discussing. The magnifying glasses indicate where we're going to dig a little deeper. So that you'll see the types of documents that we'll be looking at primarily are patent office transmittals, but then also IP transfer agreements, and then looking at how patent offices in different countries view those, and also with respect to legality and enforceability, how different court systems may view those. So examples of patent office forms may be transmittals and declarations. examples of IP transfer agreements, maybe assignments, licenses, and security agreements. And we're not going to do a deep dive into powers of attorney today, but Mike might give some comment on that later. Bree, could we have the next slide, please? Yeah, so at a very high level, who you're going to be hearing from today is Peter, who's going to be dealing very quickly with US PTO requirements, and then also electronic signature setup and workflows and our experiences with some electronic signature software. And then Mike and I are going to do a little bit of a deeper dive into the law of electronic and digital signatures and agreements, and dealing particularly on cases where there may be some challenges, and just pointing out some of the risks and challenges that we have encountered over the years. And then we'll hopefully have some time for a Q&A at the end of that. Yep. So with that, I'm going to basically hand things over to Peter, who's going to start the discussion of PTO requirements. Peter?
Thank you, Andre, and thank you everyone joining us from their home offices. Apologies in advance if you hear a sound of loud children coming from the background of my home office. So the first place we like to start here is what are the PTO requirements for electronic signatures? Most of the people joining us today are probably familiar with the S-signature. It's good to go over the basics. So an S-signature at its core is any signature made by electronic or mechanical means. It requires that forward slashes be present both before and after that signature. And it also must consist of only letters or Arabic numerals, commas, periods, apostrophes, etc. No emojis, please. Next slide, please. So in addition to that, one thing to consider about S-signatures, it needs to be reasonably specific enough so that the identity of the signer can be readily recognized. There is some leeway there, but essentially the signature present should be recognizable and as the person signing. Additionally, there's an additional requirement for patent practitioners signing documents that their registration number is either present below or adjacent their S-signature. Next slide, please. So the USPTO did a great job many years ago. They put a page up of proper and improper S-signature examples. I highlighted a few here, and we can quickly go over what is proper and what is improper. So in the left column, the standard S-signature is a typed S-signature bracketed by slashes with the name present below the signature line. You can see in the second, Marcia A. Inventor is more of a stylized font, also similarly bracketed by slashes, which is also proper. And the last example on the lower left is one of a patent practitioner signing Joe Q. Attorney, which includes his registration number adjacent his name below the signature line. You can also in that space use the number symbol. It's acceptable. As examples of improper S-signatures, the first example I have is of a digital DocuSign signature. This will likely be considered improper by the Patent Office for a couple of reasons. We're obviously missing the slashes that need to bracket the signature. We are missing an identification of the person, John Doe, below where he is signed. And we have some extraneous characters that may get bounced. The second example is, although cute, Marcia A. Inventor has put in a little smiley face that's going to be bounced as non-Arabic characters. And then finally, one that we often see are double slashes for Joe Q. Attorney, another example of improper signature. Next slide, please.
And Peter, I just interject over there. So those S-signatures are, when I talked about the different types of documents at the beginning, those are particularly with respect to, transmittals on PTO, correspondence, you know, and this wouldn't apply, for example, to assignments necessarily. It doesn't. The PTO requirements are with respect to documents that are addressed to them, that they'll review, as opposed to you know, as opposed to other documents we may file, like assignments at the Patent Office.
And that's a great point that Andre just made, is the ESIGN are for documents being filed electronically through the EFS system that the PTO currently uses. The EPAS system for assignments and will have different requirements, and there's more leniency as far as what kinds of signatures be accepted. Next slide, please. So as Andre touched on earlier, Patent Office correspondence is permitted when filing electronically and with the Office of Electronic Filing System. Currently the EFS system, future system would be the Patent Center. That's in beta testing now. Historically, the only handwritten signatures that were required to be filed were certain correspondence with the OED and certain payments by credit card. However, in March 2020, the USPTO indicated that it considered the COVID epidemic or pandemic to be an extraordinary situation, and they waived the requirements for those handwritten signature situations before the OED and regarding credit cards. Next slide, please. So want to show a couple examples as we're all displaced to our home offices of a in-office signature workflow that all of you may be familiar with, and a working from home signature workflow. In the past, it would be a typical situation where a law firm generates formal documents for signatures to send to an in-house contact at a corporation, who would then send those out to inventors and either have the inventors print, scan, and mail those back to the law firm, or send those back through the in-house contact. Now, with all of our, so many people displaced working from home, a situation where the law firm inventors can quickly obtain those signatures and return those signatures for filing is a more useful workflow. Next slide, please. So some of the reasons why the traditional scanning or printing, scanning, signing, and returning to law firms for filing is not conducive to the working from home environment. And I'm sure a lot of you are realizing this as you get up and running with your home offices. Hardware, a lack of printer scanner fax for returning those. Software issues, PDF programs vary widely, and a lot of people, if they're not used to working in PDF, may just only have a reader where they can apply a stamp or other signature or type signature. Mail, both access to supplies and access to postal services is currently fairly limited for people sheltering in place. It's even more difficult to reach inventors and signers these days because of everyone juggling so many responsibilities. Additionally, errors in signed documents now more than ever can lead to lengthy cycles of getting corrected documents. And finally, with first to file before the Patent Office under AIA, delays in obtaining signatures can lead to delays in filing. So it's even more critical now to shorten that cycle and get signatures back and on file as soon as possible. Next slide, please. So one, and the subject of this webinar, one tool to use is electronic signature software for shortening that cycle and creating that workflow between a law firm and inventors. Some of the advantages are, obviously signing is easy. All you need typically for someone to sign is a web browser, and they can sign on their phone with a stylus or their finger. They can sign by typing in a web browser from home. So signing becomes much easier when an inventor or an attorney signing simply needs access to a web browser. Additionally, there's multiple ways to sign. You can draw your signature. You can insert a stamp representation of your signature. You can type or do a stylized type of your signature and store those for reuse. Electronic software will typically include a built-in workflow. This is particularly advantageous when you have people that need to be able to limit errors in what is sent back to them, and their ability to follow up with people regarding issues is limited. One question that often comes up is, can in-house contacts be built into that workflow? And that's absolutely true. It's true for some of our clients that we'll have in-house contacts still using electronic software that we have seats to, but we'll use them as a document coordinator and send it to the people who have traditionally printed and obtained signatures in person can be part of the workflow. Obviously, speed from start to finish is of the essence. We found at our firm that when we first went to electronic signatures, that we cut approximately 5 days off the average return time and 5 days off the average filing time for patent applications. Some additional notes, audit reports, certificates of completion. It's a great verification tool that you can see. You can share signature access with additional people at your firm or company. This is particularly helpful if people may be hard to reach within your organization. You may have an unexpected absence in light of the issues with COVID. So to be able to share their jobs and find out what documents are out for signature or what documents have been returned to the law firm for signature or for filing is especially helpful from electronic signature software. And as I mentioned before, you need not have necessarily, companies need not have seats of a electronic signature software like DocuSign or Adobe Sign to be part of that workflow. If they're not preparing documents and they're just coordinating the sending for signatures, they can be part of that workflow without having to, purchase an enterprise subscription. Next slide, please. So when you're evaluating electronic signature software, if you've gotten this far with me, some of the things that we looked at when we were evaluating, and we've used both Adobe Sign and DocuSign in our firm and have been using electronic signature software for the last 7 years. Obviously, database security, document security is paramount. One thing to look very closely at is document output, what comes back from the signers. This is particularly important with regards to people who are then taking those documents and filing them in an electronic filing system, whether it's EFS or EPAS or the Patent Center in the future, to make sure those documents that come back can be readily uploaded, that they don't contain embedded fonts, that they can be combined with other PDFs for a filing package. So that is a really important consideration for the patent practitioners. The ability to generate audit trails and certificates of completion. This is great for showing backup information about when documents were sent for signature, when they were viewed, what email address received them, what IP address, who returned them, all those, and even people who did not return them for backup documentation should you need to file, say, a substitute statement when you can't receive or you can't get back a declaration from an inventor. Integration with existing software. This is really important for our firm to be able to take the workflow and the the offerings of the electronic signature software and build it into software we're already utilizing. For us, it would be Outlook would be a great example where you can plug and add in to easily pull documents from an email straight into sending to an inventor or attorney for a signature. Ease of use, obviously you're looking both at the preparer and signer side, and as I mentioned before, the ability to sign on a mobile phone is important. Ease of configuration. Doesn't need to be configured. How much internal resources might you need to get yourselves up and running using that software? And some next point would be, compliance with applicable rules and regulations, which Andre and Mike will touch on after I'm done here. Pricing models, how many number of users within your organization will need access, and versus how many transactions do you anticipate? There's different pricing models with most electronic signature software providers. Knowing how many documents you'll likely want signed and how many users, whether this can be spread broadly or within a couple power users, is important consideration. And then finally, what kind of customer support are you likely to receive? Is it in-person support? Is it email chats with support elsewhere? So those are all important considerations when you're evaluating software options. Next slide, please. So you move to the setup stage, and just wanted to touch on a few things that have come up with us that are important to set up before you roll out your electronic signature software. Document security and password protection. At a basic level, making sure that you have set in place for your clients some level of security that meets their prerequisites. For password security for documents, does the software have the ability to edit the documents and essentially open them up to combining with other documents when you get them back, or is it locked down? So, an administrator would like to be able to put those in place and have them ready to go before those documents start coming back from signers. Obviously, configuration with those related softwares, whether that's Outlook, SharePoint, OneDrive, something for pulling documents into an electronic software, or for archival purposes, a lot of these will back up signed documents to a provider like Box to keep a record of everything that was signed and audit logs that were received back or certificates of completion. Additionally, as I mentioned before, one of the huge benefits of electronic signature software is shared access should someone be unexpectedly unavailable to access an account. So when documents come back, who else is able to retrieve those documents and get those on file? And is that an administrator or is it a backup? And then finally, all the electronic signature softwares are going to have some level of template creation available. We leverage document text tags pretty heavily with building those into our existing dynamic forms. So if you're a company that uses merges, say for a declaration or an assignment document, and you can insert standard text tags that when uploaded into the software recognize a signature field, a date field, an initial field, a digital signature field. So to be able to create those templates or to incorporate templates functionality into your existing documents is something you'll want to do in advance of rolling this out to users. And then finally, branding and creating, client-specific wording that's going to accompany the jobs that you send out to your clients. Next slide, please. Next up would be, after you've put in place all your administrator setup, what steps should you be taking before rolling out to users or to roll out to users? First and foremost, test. Be able to see both what the preparer is seeing and different ways in which documents can be wrongly prepared and sent, and then what the signer is seeing as well. Is it a clear what is being asked of them? Is the document easy to sign and return? What types of issues do you need to troubleshoot early? Additionally, users are going to wonder as you roll out new software, how is this changing the workflow that I currently have? And it's good to be able to answer to them early, how do we go about adjusting your workflow to seamlessly integrate this new software? Preloading of signatures for signers is great for if you have a large group of attorneys that are going to be signing things, to be able to populate their signatures prior to them becoming users. And then creating extensive training materials for your new users and for potential signers is a must. To know what types of things that they're going to be seeing, remind them of how these documents are produced, and how to take the documents that are produced and move them to a patent office filing situation. And finally, what things have you put in place to archive documents either manually or automatically, so that you have copies of everything that was signed and audit logs to show the signature details. Next slide, please. So I got one final slide that, in our experience with our software, what are the subjective truths that we've learned at my firm? First one is, invariably, when Inventor's signature is urgently needed, suddenly they can't find a pen, aren't near a computer, their ink cartridges just ran dry, and they can't get to a post office. This is true of so many situations that it's great to be able to point to electronic software for getting signatures and say, that's fine. As long as you have access to a smartphone, I can get you documents for signature. Next subjective truth. Attorneys always want their electronic signature to look exactly like their handwritten signature. This is unfortunately and always true, and all the attorneys on here know that they would like their handwritten signature and electronic signature to look similar. I've tried long and hard to draw my signature with my finger, and John Hancock would be embarrassed for what I put down. Next one. Document signers have a remarkable and uncanny ability to creatively execute documents. Whether this is dating the document for last year, signing the date field and dating the sign field, or deciding now is the best time to introduce your avatar as your signature. The workflows built into electronic signature software prevent some of the creativity from being free-flowing, and can lock down to make sure the documents you get back are documents you can use. And last one, nobody once familiar with this software and how to use it will wax nostalgic for the days of printing, signing, scanning, or mailing signature pages back. Once you've taken the leap, the efficiencies are remarkable, and although any reticence that people may have initially about jumping in are quickly dispelled by the return on investment. And with that, I will turn over to Andre, who can touch on some of the issues with electronic signatures versus digital signatures. Thank you.
Yeah, thanks, Peter. Appreciate that. I see we actually have three questions that, Peter, maybe related a bit more to your, the subject matter you've been through. I'm thinking it may be a good idea to just quickly hit those now. So I'll probably just read them to you, Peter, if that's okay, and you can speak to this. So the first one was, any thoughts on whether the DocuSign frame would be problematic if there were slashes around John Doe? So the DocuSign example you had there, if the signer just put a slash before and after his or her name, would that be problematic from the Patent Office perspective?
So I know we have some representatives of the Patent Office on the call who maybe I'll confirm at later on here, but I think the issue with John Doe and slashes is that we've had that bounced back from the Patent Office as non-compliant in the past because of the additional characters and non-Arabic items that may be inserted. Additionally, I think in the example we use, the name is not present below the line as well to identify who the signature is for.
Mm-hmm. I think that's correct, Peter. Peter, the next one was, for clarity, please confirm if the USPTO accepts e-signatures for declarations, and then also how about inventor assignment documents. Peter, I think my understanding is that yes, for declarations, e-signatures are acceptable. As far as assignment documents, the PTO does not conduct any assessment of that and would really accept what is sent in.
Right, absolutely right. I think the assignment documents would they'll be readily accepted, even unless other forms of electronic signature will likely be accepted on assignment documents.
Yeah, and we're going to be diving into assignment documents in the next part because that's kind of really a key issue. And I think that kind of answers the next question as well. What are the PTO requirements for assignment documents? We're going to be tackling that in the next few slides and kind of pointing out some of the challenges there, because I think what the Patent Office accepts and what is going to stand up in a court of law may be different. And then we've also got all the international jurisdictions where we're dealing with assignments and what is accepted by various patent offices worldwide, and also what would be most legally enforceable worldwide. But thanks. I think that gives me a good intro to this next slide here. And really what I'm hoping to do here is tee things up for Mike, who's going to be really giving a more in-depth discussion regarding some of the challenges of digital signatures, particularly with application to IP transfer agreements and contracts like assignments. So very broadly, just to get some clarity around terminology over here, the term electronic electronic signature can take many forms and covers many things, including typing an S between slashes in front of a person's name to indicate that it's a conformed digital signature, a click-through on a click-through agreement, just clicking accept, or a similar attestation on an electronic agreement, emailing a scanned signature, faxing a signature, or even sending an email saying I agree, would all be kind of covered by the broad term electronic signatures. If we dive particularly into the US situation, you'll see two broad terms used. The one is electronic signatures, and this is really an umbrella term that encompasses any electronic process that indicates acceptance of an agreement or a record. And I gave some examples of those earlier. On the other hand, a digital signature generally tends to refer to a subspecies of e-signature that is, certificate-based, that uses a certificate-based digital ID, which is typically issued from a certificate authority and that is unique to each signer and is used to demonstrate, proof of signing. So most of the electronic signature platforms that Peter alluded to, DocuSign, Adobe, and a bunch of others, support, e-signatures generally, but can also be set up to support digital signatures. And it may be that in certain circumstances, you've got a package that you want an inventor to sign, which has a combination of e-signatures and digital signatures. You may want to, have certain signatures have a higher degree of, authentication. But we'll get into that in the following slides. Next slide, please. Yeah, so if we kind of jump to international, we see a number of international jurisdictions and countries, as opposed to referencing electronic signatures and digital signatures, reference these tiers of electronic signature. So tier 1 being a simple electronic signature, and this really just covers any data that is attached to or associated with other electronic data, with some level of authentication regarding the identity of the person doing the attaching or the associating. Next step up is, this tier 2, which is termed an advanced electronic signature, or AES. And this one differs from the simple one that it provides some degree of tamper-proofing or a tamper seal, making it, this normally requires, an extra step by the person signing. So it makes it a little less easy to use, but still not overly burdensome. And then we have tier 3, which are qualified electronic signatures, or QES. And this is, the one that requires the most hoops to jump through, probably the least easy from a user perspective, and differentiates from the other 2 in that it has a third-party verification or token. I'd just like to, if you can advance to the next slide, please. I'd like to touch on some of the considerations for the legal validity of signatures. Particularly in the US, these considerations may be taken into account when measuring or assessing the strength of the validity of an electronic signature. And that should be, separate from the validity of the agreement itself. This is just looking at the validity of the electronic signature. I would also point out that most of the electronic signature platforms that Peter's discussed do allow for customization of processes. That you can basically turn the dials on any of these considerations. So you can put things in place, and I'll touch on some of those now. So basically, the first one is intent, and this is really just a demonstration that the signer had a definite intent to sign. So one way you can increase the bar on this is to build in a clear option not to sign into your workflow. So it's like, if you prefer not to sign this, go here. Second one is consent, and this is really a level of proof that the signer consented to conduct their business electronically. So this might be an express requirement that the user provide before signing. You could also provide them with the option to complete the form on paper. But we would point out that consent can typically be a greater issue on consumer contracts, for example, insurance contracts, than the type of documents we're discussing here. An important one is attribution, which is the third one here. And this is really the context and circumstances that, should clearly, attribute the signature to a particular user. So, the information that's typically used for attribution is a detailed audit trail. And again, Peter touched on, you can kind of customize how much audit trail you want, but this is one of the big advantages of electronic signature systems, and particularly using a reputable electronic signature platform, is that it does create automatically a lot of the time this detailed audit trail for you, which gives a high level of attribution. Some providers also have a 2-step identification system for signers, which can again increase attribution. And the final one here really is association, and that really, how strongly are you associating the signature with the document? And there, a tamper seal is a good way of doing that. Anyway, with that background, I'm going to hand over to Mike, who's going to go give a deeper dive into some of the requirements of some of the agencies and laws around the world, and if you're considering using electronic signatures, what are some of the things you should be aware of as you embark on that process. So with that, Mike, you ready to roll?
Thanks very much, Andre. Those requirements that Andre just identified come up in the US by virtue of a kind of odd legal construct, excuse me, where we have a parallel national act, ESIGN, and a Uniform Electronics Act with the states that came about essentially simultaneously. Just very briefly, a few states had enacted electronic signatures acts that were inconsistent with one another, which spurred, generally speaking, some push for a uniform act and for a national act. What's particularly unusual in this situation is that the 2 acts specifically are intended to work in tandem. The ESIGN Act is very broad and high level, which to some extent the UETA is also, but they each have their own specific provisions that they bring to the table. Both of them are permissive in that they don't really instruct what will be done. They just provide that electronic signatures in a wide variety of situations, not subject to some exceptions, suffice in place of a written signature and do not provide a basis for invalidating a contract or other transaction. Pardon me. So with that, next slide, please. So ESIGN is very broad. If you see it, what constitutes a signature, electronic sound symbol or a process attached or logically associated with a record of some type and adopted with intent. So almost anything can qualify as an electronic signature within that definition, including perhaps a check mark and that sort of thing. Very, very broad. The Act, as I said, is permissive, stating that transactions or contracts may not be denied legal effect validity because it's an electronic form or has an electronic signature. So that allows a lot of latitude. UETA builds on that somewhat by providing a little bit of meaning for consent, which is in some ways closely associated with the intent. Consent in some parts relates to electronic communications in general. There are some other provisions in ESIGN relative to certain types of consumer contracts that add additional meat onto that. But in general, consent just can be determined from the interactions of the parties and the other agreements and their actions themselves. And as Andre was talking about, attribution is an important part. At some point, if you need to enforce or prove the efficacy of a contract, you may have to prove that the act is one of the person who signed. UETA is very open as to how that might be done. Some form of audit trail is probably the most natural and reasonable way of doing that. And as Andre alluded to, different forms of electronic signature have different degrees of audit trails that are available to a person that wants to defend the contract. Once again, the attribution is determined from the circumstances or agreement between the parties. So it's a pretty broad circumstance. One thing to note with this parallel construct is that so long as a state has adopted UETA in its proposed model form, then there is no preemption by ESIGN, and they are fully consonant in that regard. Only if a state has varied and adopted a different version of UETA is there a risk of preemption, and that is only to the extent it is inconsistent with a requirement of ESIGN. So for example, ESIGN has a very broad statement of an electronic signature. If a state adopted a very restrictive rule as to what could constitute an electronic signature, then that would probably be preempted by ESIGN. Whereas if they just offered, as some states do, additional benefits or attributes to some form of electronic signature, that's perfectly consistent and is not subject to a preemption argument. I just want to note it because we have some people on here that would be involved with software licenses and the like. Software licenses, various agreements for development of computer programs and the like are probably subject to control by the Uniform Computer Information Transactions Act. So probably outside the scope of this framework, depending upon other exceptions that are present regarding ESIGN and UETA. But for purposes of our talk today, I'm just thinking in terms of patent assignment agreements. One other thing to note is that both bodies of law authorize notarial acts to be electronic also. Though again, that's permissive. And whether that's permitted and the manner in which it's permitted is a matter of state law. For example, last month, New York issued a directive that for 30 days, which expired, I think, last Sunday, there could be virtual notarization through use of video conference and electronic communication of documents with some certain prerequisites. So they expressly authorized a virtual notarization for that time period. Okay, next slide, please. I'm going to address various considerations that you may want to think about in terms of whether to adopt electronic signatures or how to do them. I'm looking at this primarily in the context of a US assignment. At this point, we'll get into other considerations. So as is pretty well established, enforceability of an assignment is generally a matter of state law, except when the Federal Circuit decides that it has authority that governs how certain transfers are supposed to be interpreted. There's no limitation on persons being in the US, just as with signatures on wet assignments. The concern that could exist, however, is if you had someone resident in another country, could there be a conflict of law issue if you had a resident of the other country providing an electronic signature for transmittal here? I think one consideration in that is, going back to the state law aspect, does the person have sufficient contacts with the US and with the state for state law to reasonably have jurisdiction? For example, if you have a US resident who happens to be traveling to Europe and there applies an electronic signature, I do not see a particular concern in that circumstance at all. If, on the other hand, you had a, let's say, Singapore inventor who works for a Singapore subsidiary assigning a patent to the US parent, a question could arise as to whether or not that person had sufficient contacts for a US state law to be applicable. So as I note, ESIGN and UTA are generally uniform, though, as I said, some exceptions do exist, apparently without preemption. Some states apply multiple levels of standards for different security mechanisms. They also can apply different standards as to what constitutes consent or attribution. And attribution, as Andre was commenting, is closely allied with security. It's how are you able to establish that link to the person? So there are variations that exist there. Generally speaking, I don't think they're particularly significant, except as to the availability in some states of an additional tier with security. For example, in Illinois, a simple electronic signature serves as a valid contract in the absence of any proof. A higher level digital security signature has a presumption of validity. So there are advantages to it when it's available. Another consideration is to have a strategy for maintaining the documentation of the audit trail. In effect, that is a part of the assignment. If you have to enforce that assignment, you are going to have to show that attribution as discussed a minute ago. So you need to have access to that. Do you want that to reside exclusively with your outside counsel? Do you want to specify how they maintain it? Maybe it would be preferable for you to have a record that you kept with your copy of the assignment as you would other assignment documents. Finally, the last, a very simple signature certainly suffices under ESIGN and UTEA as an adequate signature for a assignment that's going to be applied, at least in the US. But is that the best circumstance for your company? Would you like to have a more secure technology that has a more complete audit trail to ease those proofs to the extent you need to rely on that in the future? Next slide, please. This slide is really just to identify there's a wide variety of laws out there. They have significant differences, though there are some general categorizations that can be made. The US and other common law states generally have what we described earlier that might be characterized as a fairly minimalist approach. They're permissive, they just make electronic signatures broadly equivalent, but do not relate to a specific technology. The next level up would be two-tier jurisdictions. Europe follows that, much of Asia, Latin America, where it is a simple signature is valid, but may more easily be challenged than a higher tier, more secure digital signal. And then finally, the last one would be, an example is India, statutes that specify certain technologies that have to be implemented. There's two options in India. One of them requires certification by a certifying authority that the last time I looked was a local authority. So perhaps not available easily to the rest of the world. Okay, next slide, please. The transfer of rights to priority under the Paris Convention has been a pretty hot topic for about the past 6 years by virtue of the Cook case in the UK and the more recent CRISPR decisions in EPO. And that's governed by Paris Convention Article 4, A1, which provides for that right of priority and the possibility of it being transferred to a successor in title. One thing that's odd, though, is the Paris Convention is completely silent as to the governing law about perfection of that transfer. So there is no way to resolve that conflict, and other jurisdictions don't always defer to the law regarding the initial transfer. You know, for example, nunc pro tunc assignments are accepted in the US. They have been soundly rejected as appropriate by EPO. The EPO has failed to recognize other provisions. As we'll get to, they even have rejected the digital signatures authorized in the EU. One other example is that China doesn't recognize transfers by virtue of an employment agreement. Okay, so I'm getting short on time, so let's go to the next slide. So just briefly addressing Europe and the UK, they have the multiple tiers of verification standards. Notwithstanding that in Europe, the EPO will not accept an electronic signature on an assignment, though it'll accept a signed copy of an ink signature. And there was a recent decision where the EPO legal division expressly considered that the EPO requirement constituted autonomous law, which superseded the EU law. So at least until something changes in that respect, there's probably not going to be a lot more flexibility from the EU. In the UK, electronic signatures are pretty easily accepted, but a surprising note is that a power of attorney is considered equivalent to a deed, and it has to be signed by a notary in the same room as the signer. So at least in that circumstance for the UK, electronic signatures, while generally permitted and useful, are not a perfect solution. Next slide, please. China has an electronic signature law that's been in place since 2005, but it does not apply to patents, applicants, and inventors. So they will not accept an electronic signature. One workaround, though, is that for many circumstances, as long as there is a prior assignment, even with electronic signatures that has been recorded in the USPTO, a certified copy will be accepted. Next slide. Finally, India, as I noted, has two different forms of digital signatures. The first version may be one that's relatively easy to comply with. The second one likely is going to be much more difficult for non-Indian signing parties. So with all that, let's go to the next slide. In assessing uncertainty, in the first case, it's a US application, you've got US-based inventors. There seems to be little question about applicability and validity of the contract. You're really only considering what sort of audit trail do I need and or want. If you start filing that US application in another country, consider or seek advice regarding any implications that may exist from the countries that are of interest. If you're direct filing an application, that's going to raise some red flags as to, for example, if you were filing in China, you would know that that would definitely be a problem. And any application having non-US based inventors is at least worthy of considering. It may not be an issue, but you at least need to give thought to that. And then finally, if you've got jurisdictions that expressly reject e-signatures, that's going to be a harder decision. Next slide, please. So looking forward, wet signatures are still the gold standard, but certainly right now they are less convenient than at other times. You'll be able to use them everywhere, but in your circumstance, or at least as to a specific property, do you have to use them everywhere? Although electronic signatures are increasingly accepted, some of the major patent offices seem to be lagging the trend. And there's always going to be an issue with non-uniformity of national requirements, just as there are to some extent in ink sign signatures with some countries requiring acknowledgement by the ESIGN and others not requiring. We already talked about the sufficiency for US filings. The only other point I'd like to say now, given some of the difficulties, if it's going to be harder to get a wet assignment or ink assignment at this point in time, or if it's going to be delayed, it would seem it would likely be preferable to have one with an electronic assignment to not having an express assignment. It at least gives you an argument and a basis to prove the transfer, and you should be able to follow up with a ratification or confirmatory assignment when that becomes feasible. And in the normal situation, or at least the common situation, with a company and an inventor who is subject to an employment agreement that necessitates or achieves the transfer, that's in essence what we would be doing with the written assignment. Anyway, is we're having a written confirmation of a transfer that we assert to previously exist. So it seems to be a point worth considering. And with that, I'll turn it back to Andre.
Great. No, thanks, thanks, Mike. Appreciate that. And yeah, I think that wraps it up. We're over time already, but as I put in the notes over there, if anyone has any specific questions about how the Schwegman firm has implemented this, and please feel free to reach out to Peter. And just in conclusion, thanking everyone for attending. Appreciate the time. We will be distributing the slides after this, and again, if anyone has any questions on particularly regarding assignments, please feel free to reach out to Mike or myself, and we'll do our best to share what we know at the moment. As I said, this is kind of a rapidly evolving area of law, and each country is doing something a little differently. But happy to share what we know. Okay, well, thanks everyone. That's all I have.
Thanks again, everyone, for joining. And our next webinar is coming up tomorrow, when Schwegman's Director of China Intellectual Property Practice, Aaron Winninger, will present a webinar about expediting examination in China. And if you visit the SLW Institute on the Schwegman website, you can find some more details then. Thank you again for joining us, and be well.